All right, so I think, people are still coming in. Let me give folks a few seconds before I make just some administrative announcements about the presentation, just so everybody captures them. So once again, my name is Rohini Singh. I'm here to give a presentation on navigating school discipline in New York City. Just some housekeeping issues. First, we will be sending out a copy of this PowerPoint by Monday. And so please know that you'll get copies of all these slides. And then secondly, during the presentation, I'll pause a few times for questions. And the chat is disabled right now, so you won't be able to chat me directly, but you can ask questions through the Q&A feature on the Zoom toolbar. So if you go up to the Zoom toolbar and go to Q&A, you can ask a question there. I'm joined today by Liliana from Advocates for Children, who will be monitoring the Q&A and will either answer your questions as they come in or can help read out any questions that come up when I pause for questions in the presentation. And then finally, at the end of the PowerPoint, once we end the presentation, you should be redirected to a survey, a form to fill out, which is just a quick evaluation form for this presentation. It just contains necessary information that we need in order to be able to get funding to give free trainings like this to the community. So we do ask that you fill that out. I'll also try to put a link in the chat, and we'll also send out the link to the survey with the presentation PowerPoint on Monday. And so with that, I think we will probably get started. We have a lot to cover. Yeah, and so please use the Q&A feature. And all right, so yeah, so today's training, first I'll give a quick introduction of Advocates for Children and the School Justice Project, which I'm a part of at Advocates for Children. Then I'll talk a little bit about types of suspensions and parents' rights through the suspension process. And then I'll talk about legal protections for students with disabilities, and then just some key takeaways, that we hope you walk away with when you're trying to help families navigate the school discipline system, or if you're navigating the school discipline system yourself. So first, Advocates for Children. Advocates for Children is an independent agency that protects the rights of all New York City students. Our mission is to really ensure a high quality education for all New York City students, focusing on students from low-income backgrounds. And we provide an array of services. We have a citywide education helpline. The number's on the screen. It's open Monday through Thursday, 10 a.m. to 4 p.m. And anyone in New York City can call: parents, students, school staff members, providers, community members, and ask our education specialists an education-related question. We also have a number of guides and resources on our website. I encourage you to go on our website, click the link for guides and resources, and you'll see we have a lot of guides translated into different languages on various topics related to education in New York City. We also give free workshops and trainings just like this one to schools, to organizations. In these sort of remote times, we're providing a lot of webinars. And so we encourage you to look at our website also to see if there are other topics that you or folks you are working with or know might be interested in. And then finally, the bulk of our services is to provide free legal services to low-income families. And so we help families navigate the special education system. We help families in the suspension hearing process and to help them navigate school discipline issues. And so, yeah, so in order to access our services, really the best way is to call our helpline, where if you're seeking legal representation, you could be screened to see if you're eligible for our services. A little bit about our suspension and discipline work. So I'm part of the School Justice Project at Advocates for Children, and we help young people who are facing juvenile and/or criminal justice system involvement, school suspension, exclusion from school due to their behavior, students that are accused of bullying or the target of bullying behavior. We also advocate systemically for alternatives to, we advocate individually for alternatives to discipline and for behavior supports and services so that students can remain in school. And then systemically, we also participate in city and statewide coalitions to reform school discipline policies and procedures and advocate for investments and supports for students. So before we launch into specific rights in the school discipline process, I want to talk a little bit about why this is important and why it's important that parents know their rights, and really the harm that suspensions can cause. And so students who are suspended have been found to be more likely to miss a class, be held back a grade, be suspended again, drop out, and potentially get arrested. And so this is what's known as the school to prison pipeline. Additionally, without supports and interventions, students could also be improperly told to stay home, placed on a truncated school schedule, sent to hospital emergency rooms for behavior that could be managed by the school, and otherwise excluded and in essence pushed out of school. Just a little bit about the data related to suspensions. So between 2013 and 2014 and 2018 and 2019, the number of principal suspensions and long-term suspensions did decline. However, racial disproportionality and disparities by disability status still persist. And so while Black students only make up 22% of the population in New York City schools, they receive about 43% of suspensions. And students with disabilities are 20% of the population, but they receive 40% of suspensions in New York City schools. So this disproportionality is pretty alarming. We are trying to advocate for alternatives to discipline, for more the education about parents' rights in the discipline process to ensure that, there is an overall decrease in suspensions, and then also that the disparate impact does not fall upon Black students and students with disabilities. So next, I'm going to turn to do a quick poll to see, what your knowledge is about the school discipline process and supports for parents in schools. So I'm using this feature called Slido. I don't know if folks are familiar with it. If you could either go to this website, slido.com, and type in this access code, or you can actually just use your phone and scan this QR code. And you should be able to then participate in this Q&A. So the first question is, the school can call you to come pick your child up early. I'll give folks a little bit of time. I know the tech might be a little challenging, but again, you can either scan this QR code and open up the poll on your phone, or you can go to slido.com on your computer and type in this access code. Great. It seems like we have some folks trickling in. Some answers trickling in. I'll wait a few seconds. Okay, so it seems like we have, it looks like most people have selected false, but there are some folks that have selected true. So the answer to this is actually false. So a school cannot call you to come pick your child up early. They have to be able to manage their behavior in schools, and schools should be equipped to manage student behavior in schools. If they are, and we'll get into this a little bit later, if they are trying to send a student home, they have to follow the process to either suspend or remove a student from school through the school discipline code. Great, so the next question, and you can, I think this should launch now here if you're already logged into Slido. The next question is, the school can require a doctor's approval or no for your child to come back to school. I see. Great, thanks for those that are participating. It looks like we're getting, different answers. I see a little bit of a split here. Great, okay, so it looks like actually the majority of folks here are saying that this is true. This is actually false. A school can't require a doctor's approval or a note for your child to come back to school. We'll talk a little bit about, students' rights in the process, in the discipline process, but this is actually not true. It's false. A school can't exclude a student from returning to school conditioned on some sort of doctor's approval or doctor's note. Great. The next question is, after a suspension, you have to meet with the principal before your child can come back to school. So, your child has served their suspension, but the principal says, I don't want them back until you come in to meet with me. Great. It looks like here a larger majority of folks are saying false. So the answer to this question is indeed false. Once a student has served their suspension, they've served their suspension, and they are allowed to go back to school. Oftentimes schools will have some sort of reentry circle or welcome back circle or a meeting when a student comes back. But if for some reason the parent is not available or school staff is not available, they can't delay a student's return just to have that meeting. So they should still admit the student back in school and then could potentially have a meeting with you later. Great, we just have 2 more questions. So the principal can call EMS if they think your child is a danger to themselves and others. Kind of see most people are saying yes, that's true. Okay, so it does seem like the vast majority of folks are saying true. So this is a little bit of a trick question. Yes, it is true. A principal can call EMS if they think your child is a danger to themselves or others. However, there are regulations within the New York City Department of Education that does require schools to have a crisis plan in place with dedicated school personnel who should be trained to be able to respond to a crisis, and for them to actually follow that plan prior to calling 911 or EMS. So yes, it is possible for principals, and principals can call EMS, but they're not required to call EMS. And there are certain steps that they should be taking prior to calling EMS if they think, if a student is in crisis. Great. And then the final question is, true or false, a student can be suspended for a year. I see a split here. So I'm sure many folks have heard, that there were recent changes to the Discipline Code in 2019. Technically, the answer to this question is yes, a student can still be suspended for an entire school year. However, given the changes to the code, it's only in very limited circumstances. So again, a little bit of a trick question, but technically true, even though it is much less common now that there have been changes to the School Discipline Code. Great. Thank you, everyone, for participating in that. I'm going to turn now to talk about the different types of suspensions and removals in New York City, and what parents' rights are through that process. So the New York City Discipline Code is the document that I'll be referring to and talking about today. Just so folks know, the vast majority of this presentation will be about students that are in New York City public schools. If your child's in a charter school, unfortunately, this discipline code does not apply to them. Charter schools can design their own discipline code, but that doesn't mean that they aren't subject to any laws. They must still abide by state regulations. So all schools should have some sort of process, some sort of due process for parents and students when a school is claiming that they have violated a school's discipline code. But all the information about rights and specific timelines here that I'm discussing today only applies to New York City public schools. So the citywide behavioral expectations to support student learning, this is the basis for all suspensions in New York City district schools. It's available online. It should be updated annually, but the last version is not since 2019. There are different versions for grades K through 5 and 6 through 12, and it includes a DOE mission statement on school climate, a student bill of rights and responsibilities, And as I mentioned before, it was substantially modified in September 2019 to lessen the amount of time students can be suspended for a number of different infractions, but also includes a greater focus on behavior interventions and supports for students. In the code, and this is, this is a really good tool for advocacy if you're a parent or a provider that's working with a family. Beginning on page 13 in the code, you'll see a lot of information about progressive discipline, as well as a glossary of positive behavior, supports and interventions, and a glossary of restorative practices that schools are actually expected to use instead of or in addition to any sort of suspension. So if you're working with a student who's experiencing behavioral challenges, you can try to make sure that the school is using some of these techniques and not just resorting to suspensions or classroom removals. And you can say this is what's inside the DOE's own policy, the discipline code, and is required in some circumstances by the discipline code itself. After that section, there's also a section on bullying, a section on supports for students with disabilities, and then starting on page 25, information on different disciplinary responses. This is what a sample page of the different types of infractions are included in a discipline code. So I actually took one page of the discipline code and split it into two different slides. So if you do look at the discipline code, you will see that towards the end, there's a list of different infractions that are categorized by number and by different types of levels of infractions. And so it'll list the infractions, and then after the infraction, it'll say, D through K, which is the range of disciplinary responses that a school can impose based on whether or not they found that a student violated that infraction. So this is the top list of infractions, and then here you'll see this is the different range of disciplinary responses. It's important to note that this range of disciplinary responses, it goes from parent conference to superintendent suspension. And so if a school is if they're alleging a student violated a certain infraction, and you look in the discipline code and you see that there's a range of disciplinary responses, and the school is jumping to the most significant response, the most serious response, then there's room for advocacy to say, have you considered something less punitive, like an in-school disciplinary conference, a parent conference, things like that. So again, the discipline code is a really important tool when you're advocating for students, so that what school, because this is what schools should be looking at when they're assessing student behavior, assessing whether it violated the discipline code, and then assessing what types of disciplinary responses they should be imposing. Something also to note is that there is a column, the column here on the right is disciplinary responses. The column on the left is supports and interventions for students. And this is a list of supports and interventions. And it says right here on the code that they may be used in tandem with disciplinary responses. And so again, it's another point of advocacy to make sure, is a school just suspending a student or just removing a student from a classroom, or are they also engaging in, guidance conference, providing individual or group counseling, creating an individualized support plan, really anything on this list. And there's more information on each of these different types of supports in the discipline code itself. And so again, I encourage you to look at it. I'll include a link to this, the discipline code with this PowerPoint presentation when we send it out to everyone on Monday. So now let's turn and talk about the different types of suspensions that are possible, or different types of discipline that are possible in New York City public schools. So there are three types of discipline. There's teachers removals, principal suspensions, and superintendent suspensions. So the first is a teacher's removal. A teacher can remove a student from a classroom for behavior that substantially disrupts the education process or substantially interferes with the teacher's authority over the class. It's important to note that every effort should be made to address substantially disruptive classroom behavior using in-class disciplinary responses. So, like a meeting with a parent-teacher conference, a meeting, along with appropriate supports and interventions prior to actually implementing a teacher's removal and removing a student from a class. A teacher can only remove a student from their own class. The removal can only be for up to 4 days, and a parent can ask for a meeting if their child is being removed from class. And if the parent asks for a meeting, the meeting must be held within 2 days. Every time a student is removed from class, the school should be calling the parent to let them know that their child is being removed. Of course, we know that this at times doesn't happen. And so if you become aware that your child is being removed from class and they're not categorizing it as a teacher's removal, it's a good opportunity to ask for a meeting and talk to the school about, you know, what supports are they putting in place to make sure that a student is in the classroom and learning and not being repeatedly removed from the classroom. Next are the 2 different types of suspensions: principal suspensions and superintendent suspensions. So principal suspensions, these are for up to 5 days. The principal is required to hold a principal suspension conference prior to imposing the suspension. And parents should be provided with written notice every time a student is being subjected to a principal suspension. And I'll go into a little bit more detail about, you know, what the notice and conference looks like in a moment. And then finally, superintendent suspensions. These are longer term suspensions. So these are the suspensions for 6 to 20 days and potentially over 20 days for some very serious level 5 infractions. These require a formal hearing in one of our suspension hearing offices here in the city. There's one in almost every borough. There's one in every borough except Staten Island right now. There is written notice required here. And again, like I mentioned, I'll be going into more detail about superintendent suspensions in a moment. These suspensions, they have to be approved by the chancellor, his designee, or a community superintendent before they're imposed. And so a school needs to seek approval in order to pursue a superintendent suspension. Now, it's important to note that no other removals are allowed. And so, you know, if a student is being, like, as I mentioned before, in the initial true/false questions, if a parent is being told to pick their student up early, you know, that's an illegal removal. That's not allowed. You know, students certainly can't just be sent home in the middle of the day without any call to a parent or any without the school engaging in any of these different processes. And so it's important to note that no other removals are allowed. And that, you know, for each of these different types of removals and suspensions, a parent has a right in that process, either to some sort of notice or a meeting. And there are limitations on schools' ability to impose these types of discipline. Just a note about other discipline. You know, expulsions are really rare in New York City schools. You can only be expelled if you're over 17 and you don't have an IEP, meaning that you're not a special education, you're not receiving special education services. You cannot use corporal punishment in New York City schools, and you cannot transfer a student without permission. That would be considered, you know, like an illegal removal from a school. All right, so let's get into a little bit more details about principal suspensions and superintendent suspensions. So for principal suspensions, as I mentioned, notice is required to the parent. It must be a written notice in the parent's language. It has to be provided to the parent by personal delivery within 24 hours. This could be by email, by mail. They can give it to the student to give to the parent, unfortunately. If it's clear that that's not going to be a reliable method for a parent to receive it, then that's arguably not an appropriate method. But it must be by personal delivery within 24 hours of you know, the principal wanting to impose a suspension. It has a statement of students' rights. It lists the reasons for the suspension, including the date, time, and place for the incident. It lists the period. It should list the period of removal, and that, again, it can only be between 1 and 5 days, and the accommodation for alternative instruction while a student is serving the suspension. And then in addition, it has to include the date, time, and place of the principal suspension conference. So the principal suspension conference, again, it must happen in most situations. It must happen prior to the suspension being imposed, except in cases where there is some sort of threat of danger. Then the principal can impose a principal suspension and then have the conference, after the suspension has already been imposed. The principal is required to attend the conference. They would decide at that conference if the suspension is justified, and the parents have rights at the conference. They can present students' version and question the version of the events and question witnesses. They have a right to an interpreter, and they can discuss a plan to how to address behavior. It's important to note that, at times we have found, and we've received calls from parents whose children are being sent home and they're not receiving the appropriate notice, or there's not any sort of principal suspension conference. It's possible to appeal and get principal suspension expunged or removed from a student's records, if that is the case, if the school didn't follow the proper procedure. Great. Now let's turn to superintendent suspensions. As I mentioned, superintendent suspensions have to be approved by someone within the central office. And so the school must get, what they do is they investigate an incident after it occurs, then they have to gather evidence and submit it, and they must get approval for the suspension from the central office. Once they get approval, they're required to call a parent immediately. And then the parent must get written notice within 24 hours, which includes the reasons for suspension, the alternative school location, details about the hearing, which must be scheduled within 5 school days, a witness list, and the parents' rights and places to call for help. The Advocates for Children is one of the nonprofit organizations that provides representation for students in suspension hearings. So we are on the list, and there are a number of different agencies that can help families at a suspension hearing or provide some advice if they're not able to provide direct representation. It's important to note that technically students are allowed to stay in school before the hearing, except where they pose a continuing danger to persons or property or an ongoing threat of disruption to the academic process. For the vast majority of infractions where a school is pursuing a superintendent suspension, then it's likely that it meets this criteria. And so that means that for the vast majority of superintendent suspensions, students will be going to an alternative school location, or called an alternate learning center, pending the hearing. This is what a sample superintendent suspension notice looks like. You'll see here that it has the information for the alternate learning center. Here it's the Brooklyn Choices alternate learning center, or the alternate school that the student will be attending. And then it has the date, time, and place of the hearing, and which should be within 5 days of the suspension notice. As I mentioned, there are suspension hearing offices in almost every borough. There's 2 in Brooklyn, one of which serves Staten Island and Brooklyn. And I think it actually used to be in Canarsie and was now just moved to Midwood, and one in downtown Brooklyn, and then one in Queens, Manhattan, and the Bronx. In addition to the daytime place of the hearing and the alternate learning center, there's also this is actually 2 separate pages. There will be one page where it just lists the charges, or what they're alleging the student did, and the date, time, and place that it happened. And then there will also potentially be a non-binding witness list where they will list what witnesses that might come to the hearing. It doesn't mean that the witnesses will definitely be there, but these are the witnesses that they might call for the hearing, or call to come to the hearing, excuse me. So the biggest piece of advice we provide to parents once they get a superintendent's suspension notice is that they must ask the school for the suspension packet. So the suspension packet is very different from the suspension notice, and it's really important that a parent receives the full suspension packet the minute that that it's available, and the minute that they hear that their student has been suspended. So the suspension packet contains basically all of the evidence that the school will be using at the suspension hearing. So it should include an occurrence report or an ORS report, witness statements, including a statement from the student if they wrote a statement, a records cover sheet, an evidence voucher if anything was confiscated, like a weapon, injury reports if there was any injury, video evidence. If the school is planning on using video evidence at the hearing, they're required to give that to the parent ahead of time, and other school records, such as the student's IEP, their transcript, attendance, documents that will be used to determine the length of suspension. So a mitigation documents, essentially, and I'll explain what that is in a moment. The parent is entitled to the full packet on request. Some schools tell parents they need to wait until right before the hearing, like the morning of the hearing. This is not true. If there are any issues, you can contact the borough suspension office, and they should ask to speak to the supervising attorney, and they will actually tell the school to that they must turn over the packet to the parent prior to the hearing. It's also really important to get the packet because a lot of organizations that represent students in suspension hearings, including Advocates for Children, we're often not able to make a determination about representation without seeing all the evidence in the packet. Once you receive the packet, really check to make sure that it has all these documents. And you can specifically ask if you feel like things are missing, you should ask the school for these particular documents. One thing about video evidence that I know does come up often when we speak to families is that if the school is not going to be using the video evidence at the hearing, it's very difficult to obtain the video evidence. So even if you know that there probably is a video, unless the school is using it, you will likely not be able to view it, unfortunately. This is a sample records cover sheet, which is one of, as I mentioned, one of the documents in the packet. It lists a student's suspension history. It lists it should list their grades. This one just says see report card. It lists, a sign-up. Then this is the second part of it's one very long page, so I just cut it into two here for 2 slides. It has a synopsis of the disciplinary record, any prior guidance, interventions, or recommendations. And then finally, most importantly, it has the principal's recommendation for the length of suspension that they're recommending. And this can be really helpful in trying to assess whether or not you want to pursue a hearing, potentially plead no contest, and I'll explain what the different options are in a moment. It's important to know how much time, the school, how long a suspension the school is pursuing, to get a sense of, how serious they're taking this and how serious the infraction is. And this is a sample witness statement. It should have the name of the witness, their position in the school, and should be signed and dated. This is a sample ORS report, or occurrence report, which should list here the specific infraction code that the student is alleged to have violated. Here, if you look under category, you'll see A51, which is the specific infraction code in the discipline code that the school is alleging that the student violated. So in terms of what parents' options are for superintendent suspension hearings, I do not have time to get into the ins and outs of representing a student at a suspension hearing or specifics about the hearing itself. But I do want to make sure that you know about that there are 3 main options when a student is facing a superintendent suspension hearing. So the first is, either the parent or the school can request an adjournment to either gather evidence, contact witnesses, or request a different hearing date if that's more convenient for the parent. And so, hearing offices will permit a parent to seek an adjournment for good cause. It's important to note that if a parent is requesting an adjournment, then the student stays at the suspension school pending that next hearing date. If the school is requesting an adjournment, then the student is actually reinstated to their regular school pending the next hearing date. Another option is to plead no contest. And this option, it waives the right to a hearing. And so no hearing will take place. None of the evidence that the school collected, so that suspension packet, none of it will be put into evidence. The student is not admitting or denying to the charges, but the charges as they're written in the suspension notice, they're sustained. After a parent pleads no contest, just the list of the charges goes to the early resolution, someone in the suspension hearing office called an early resolution counselor, who will then make a recommendation for a number of like how long a suspension a student will serve, just based on the charges and on the principal's recommendation and any sort of evidence, or mitigation evidence that the parent or the school submits into evidence. After a parent pleads no contest, if they're not satisfied with the length of suspension that their child ended up with, and they want to pursue a hearing, they have 3 days. They have 3 days of hearing about the decision, either via phone or email, or 7 days of receiving a written decision, whichever is later, in order to withdraw their no contest plea and choose to go to hearing at that time. Just some, notes on, when it might be a good time to plead no contest. So if the evidence against a student is very strong, if the student wrote a statement admitting to the behavior, that's usually enough to sustain charges in a suspension hearing. If the evidence against a student is particularly bad, so if there was a fight and the other student was very badly injured, and you don't want evidence of the injuries to go into the record, things like that. Another reason potentially is, you can potentially work out a deal with the school to amend the charges or to request a shorter suspension in agreement that you would plead no contest to the charges. And then finally, the third option is to proceed with a hearing. And a suspension hearing is broken down into 2 phases. There's a fact-finding phase where the hearing officer will, the school will present their evidence, the parent has an opportunity to present their evidence, and the fact finder will decide whether or not the charges are sustained or not sustained. And if they are sustained, then the second portion of the hearing is the mitigation portion, where both the school and the parent has an opportunity to present evidence to show why, a student should either just be immediately reinstated or get a shorter suspension than maybe what the school is recommending. And again, this is, it's a sort of a whole separate training on suspension hearing processes and how to represent a student in a suspension hearing. But this is just a basic overview of parents' options. So after superintendent suspension, after the hearing officer makes a recommendation based on the testimony and all the documents and evidence at the hearing, within 2 days of the hearing, the parent must receive notification whether the charges were dismissed or sustained, if they're sustained, where the student is assigned to attend school, and how the suspension will be reflected in the student's records, including when it will be expunged. And then within 5 days of hearing, the hearing office must mail a full report of findings and a disposition to the parent. And the student remains at the alternate learning center pending the decision, unless the parties agree otherwise, unless the school allows the student back for some reason. And then if the charges are sustained, there are, for most infractions, the different options, for most infractions, either a student will be immediately reinstated to the school, or the suspension office will determine that the suspension should be continued for 6 to 10, 11 to 15, or 16 to 20 school days. And for very serious behavior, and only with DOE main office approval, a suspension could potentially be continued for more than 20 school days, up to 1 year. And then, as I mentioned, expulsion, which is very rare and only possible for students without IEPs or special education services. In addition, the decision could recommend services. It could grant or deny a school transfer if the parent's requesting a transfer at the hearing, things like that. And then finally, there are different levels of appeals for decisions that are made in superintendent suspension hearings. So the first level is an appeal to the Chancellor or Office of Legal Services. The timing is that it must be filed within 20 school days of the date of the decision, or 10 school days from the receipt of the transcript, whichever is later. And the second level, if that appeal is not successful, is to appeal it to the New York State Education Commissioner. And that must be initiated within 30 days of the decision, unless the delay is excused by the commissioner for good cause shown in the petition. Great. Sorry, this was a lot of information. I'm going to pause for questions. I do see a few questions here. I don't know, Liliana, if there are questions.
There are a couple of questions.
Oh, I see here.
One of them is there any way to change the alternative learning center assigned pending the hearing?
Yes. So the way to do that is to talk to the suspension hearing office. And again, try to speak to the supervising attorney there and ask them if they can help initiate a transfer to a different alternative learning center. Something to note is just that there are very few ALCs, and so there are just fewer options in terms of transfers. But yes, the actual suspension hearing office, should be able to assist with that transfer.
There's another question earlier that I think is important enough to repeat. The parent wanted to know what happened with the homework and subjects when the suspension takes place. I don't know if you mentioned it.
So what happened? Sorry, let me just look through. The subjects of homework. Oh, right.
Mm-hmm.
Yeah. So I do get into this in a little bit in the next section. So students, yeah. So yes, I'll definitely answer that question in the next section of the presentation.
And I think the last one for this section is the parent has not received a superintendent suspension decision after a hearing. And so the question would be, what is the reasonable time frame for a decision to reach the family?
So technically, the DOE is supposed to provide that decision within 5 days of the hearing. We know, and we've experienced delays in our own cases with certain hearing offices, especially last school year. I mean, it's again, they are required to provide it within a certain time. If you have not received a decision and it's been that long, like a written decision, then what I would recommend is to call the hearing office and ask to speak to the supervising attorney, and ask for them to provide you with the decision or provide a timeline of when they're going to provide that decision.
Want to do one last one?
Sure. Yeah,
and
I think we are sort of running out of time a little bit. I don't know. Yeah.
Why don't we leave this one for the end?
Okay, sounds good. So I have another quick poll here. Although I guess this question was probably already answered. So the question is, what type of academic instruction are students entitled to following a suspension hearing? Is it homework, full-time instruction, state tests only, or none? And for the sake of time, I might just skip to the answer here because we do have a lot to cover in the next section. As it was answered, by someone who asked in the Q&A, students are entitled to homework, classwork, exams, and full-time instruction, while they're on suspension. And so during a principal suspension or while waiting for a suspension hearing, they're entitled to full-time instruction if they're in grades K through 8, and for high school, at least 2 hours a day of instruction. After a suspension hearing, all students who continue to be suspended have the right to full-time instruction. So now we're going to move to some of the protections for students with disabilities, and specifically, I'll be talking mostly about the manifestation determination review process. So as I mentioned earlier, we know that suspensions are disproportionately imposed on students with disabilities. And it's true even though the law gives extra protections to students with disabilities who are being disciplined in schools. So students with disabilities, they're entitled to expedited evaluations, a manifestation determination review, a suspension plan after they've been suspended and the suspension is being imposed. And they're also entitled to evaluations such as a functional behavior assessment or behavior intervention plan. So first, let's talk about, who is a student with a disability for discipline purposes. The first most obvious categories are, students that have IEPs. So students that are receiving special education services, students that have 504 plans are considered students with disabilities for discipline purposes. And then finally, and the gray area here is, students who are determined that the school is deemed to know that they have a disability. So what does it mean that a school is deemed to know? It means that, the parent has expressed some sort of concern in writing to a teacher or administrator that their child might need special education. If the parent has requested an evaluation, excuse me, and the student is going through the evaluation process, but they haven't officially started to receive services, they are still considered a student with a disability for discipline purposes. If a teacher or school staff express specific concern about a pattern of the student's behavior to their supervisors, then the student should be considered deemed to know by the school. And then if the child's behavior in school showed the need for special education services, and this is only in New York City that this applies, but if there's enough evidence that shows that the student was experiencing behavior challenges, they should have been referred for special education, they weren't, then you can argue that they should be deemed to know to have a disability and entitled to the protections that exist for students with disabilities. Some exceptions for this. If the parent did not consent to evaluations or services, if the evaluation was conducted and the school district determined the student does not have a disability, then they're not entitled to these special protections. So the first special protection is a right to expedited evaluation. So suspended students must get expedited evaluations if the parent is requesting an initial evaluation at the time of the suspension. And the school is, or if it's determined that school is deemed to know the student has a disability but they haven't been evaluated yet, they can get expedited evaluations through the discipline process. So this must be done within the evaluations must be done within 15 days of parent consent. And the parent, can make the requests to the suspension hearing office, to the school, and again, request evaluations to be expedited, given that the student is being disciplined. This really shortens the timeline for evaluations. Typically it's 60 days. And so this is a good opportunity for students that are really struggling to be able to get evaluations quickly to assess and determine what types of supports they might need in school. The next big protection that I'll be discussing today is a manifestation determination review, so an MDR. So what is an MDR? An MDR, and students with disabilities are entitled to MDRs, which are a meeting to decide if a student's behavior was caused by the student's disability or if it was a result of the school's failure to follow the student's IEP or BIP. This meeting usually takes place at a student's school. But for students in charter schools or non-public schools, this meeting will take place at the Committee on Special Education. Again, potentially for the sake of time, I'm just going to skip this poll. I apologize. So at an MDR, which is this meeting with the school, the team should make a determination of whether or not the behavior was a manifestation of the student's disability. If it's determined that the behavior is a manifestation, then the student cannot be suspended. They must return to their regular class placement, and the school must conduct a functional behavior assessment to see if a child needs a behavior intervention plan. If the behavior is not a manifestation, then the suspension continues and the student can be suspended, just like other students. But the school still must create a suspension plan so that to make sure, which is essentially a streamlined version of a student's IEP, and can include, related services, special education teacher support services, accommodations, transportation, in order to ensure that students with disabilities are still making progress towards their IEP goals while they're on suspension. And a school can still consider doing a functional behavior assessment and behavior intervention plan when the student returns to school. So when must the school hold an MDR? So the law says that a manifestation determination review must be held when there is a disciplinary change in placement. And this is defined as 2 or more suspensions or removals, where the removals add up to a total of 11 or more days in a school year. And the principal determines there's a pattern of removal. And so this could be, as it's listed here on the slide, it's a little confusing, but essentially a school must hold an MDR when the student is suspended for 11 or more days in a row, 11 or more days within a 40 school day period. or if they're suspended for 11 more days in a school year and there's some sort of pattern of removals. This is where it's really important to keep track of the number of times your child has been removed or suspended or disciplined, to ensure that they're getting this protection, this MDR, and that they're not being suspended for behavior that is a part of their disability. So what happens at an MDR meeting? What does the team have to do? Essentially, the team, which should consist of someone in the school who can interpret your child's behavior. So that could be a school psychologist, a social worker, a counselor. Typically, there's an administrator there as well, a dean or an assistant principal. Any sort of teachers that were involved or that might be able to speak to the student's behavior should be there as well. A parent, parents are obviously are required to be there, and in addition, the parent can bring advocates, can bring outside providers, and support at the MDR meeting. And at the MDR, the team they must review the student's IEP, the student's functional behavior assessment or behavior intervention plan, if that one exists, any evaluations or teacher's observations, occurrence reports, records from the parent, such as, you can bring in a letter from an outside provider talking about your child's disability or their diagnoses and how that manifests within them. And really any other information, like medical reports, school progress reports, things like that. And then at the meeting, the team will sit down and work through what's called the Manifestation Determination Review Worksheet. And I'll include a link to this with the PowerPoint when we send it out on Monday. This is really helpful to prepare because it sort of walks the team through the steps it needs to take in evaluating the different documents, identifying what a student's disability related behavior is, and then determining if the underlying incident at issue is related to the student's disability. So just some tips for preparing for MDRs. It's really important to review all of the documents and focus especially on, students' social emotional functioning, their behavior, past behaviors, things like that. When looking at the documents, making sure that a student's getting all their services on their IEP, especially at the time of an incident. If a student was supposed to receive if the student had a full-time one-to-one paraprofessional and that paraprofessional wasn't there at the time of the incident, then that could be a reason why a student could potentially be immediately reinstated if the school was not following the mandates on the student's IEP. Another, helpful thing to do is, as I mentioned before, is to really ask and encourage outside providers to participate. Just some tips for using outside providers. They could either participate at the meeting or write a letter. But it's helpful to have someone else there other than the school to provide a different perspective about that why he or she believes that the behavior was a manifestation of the child's disability, and why, and what their knowledge of the student's disability is. So I can pause here for questions. And see if there's anything that hasn't been answered yet.
And so there's anything that's outstanding. I think most of them have been answered.
Okay, great.
I think you can continue.
Great. And so just 5 school discipline takeaways that we hope you take away from this webinar today. The first is, as I mentioned, it's really important to emphasize with, either your own child or students that you're working with, that schools really should try to help students before suspending them. And so this is, should be obvious, but is something that, oftentimes in our work, we see that schools might jump to some sort of disciplinary response instead of providing some of those behavior interventions and supports I mentioned earlier. So again, use the discipline code, point to the language in there. there should be an emphasis on providing students with support instead of just resorting to school discipline. Notice must be in writing for really all suspensions. So for both principal suspensions and superintendent suspensions, students should be receiving, or parents should be receiving written notice. If a student is receiving a principal suspension, ask for, and they haven't received a principal suspension conference, ask for one because they are required to provide one, and that gives you an opportunity to find out what happened, find out how the school is addressing it, potentially argue that they should not be suspended, or advocate for supports when the student returns from the suspension. Always get the suspension packet if your child or you're working with a student that received a superintendent suspension notice. The first thing should be to ask the school to provide you with all the documents in the suspension packet, so you can assess what your options are at a suspension hearing. And then finally, there are no out-of-school suspensions. And so, there are, while a student is serving suspension, they should not be sitting home without any schoolwork or classwork. As I mentioned before, students are entitled to alternative instruction. It looks different depending on the different type of suspension, but they should be receiving some form of alternative instruction. And it should be full-time instruction if students are serving superintendent suspensions. Great. So just some wrapping up reminders. Please fill out the survey that will pop up the end of this presentation. And I could also put a link to it in the chat here so folks can see it. It just provides us with valuable information in this, about this webinar. If you need help, please call our helpline. I think there's a question here about how to access our services. The best way, as I mentioned, is to call our helpline. Similarly, if you are working with a student that received a superintendent suspension, if your child received a superintendent suspension, you can call our helpline and they can assess your case to see if we can help with representation. You can also email us at info@advocatesforchildren.org. Great. So let me put the survey in the chat. And I can stay on for a few minutes and we can pause the recording in case anybody has any questions, final questions. Great. Thank you, everyone. Please stay tuned. We're giving 2 more webinars on related topics, one on bullying in November and one on advocating for behaviors and mental health supports for students in schools in December. And so that information will be on our website and our Blackboard bulletin. You can sign up for more information there.